Okay. And then for 1 and 2 there is Mr. Mongera, is that correct?
That is correct, my lord.
Mr. Mongera for 1 and 2. And we still have no one for the interested parties, huh? Not appearance for interested parties. Yes, I have the ruling typed, and I'm going to give you copies of it shortly. So in the interest of time, it is now 4:30. I'm going to read the effective parts of it. And for our stakeholders who are in court, I will read maybe a bit of it. I'll start with at about paragraph 20. The court finds that the issue in this petition, an interlocutory application for conservatory orders, raises partly a nomination dispute, and the court is bound by Article 88(4)(e) of the Constitution to defer to the prior jurisdiction of the IEBC. There is no suggestion that the court has no jurisdiction under Article 165 and 258 to determine the issue of interpretation and constitution, even when such an issue of eligibility to contest for an office arises. Paragraph 21, I have said, at this stage, however, of hearing, the court is not able to hold that it has no jurisdiction under Article 165 and 258 of the Constitution to interpret the Constitution and to grant the declaration sought in Prayer A of the petition dated 31st of May 2022. And I quote that the third respondent does not meet the basic academic qualification of holding a degree from a university recognized in Kenya pursuant to Article 180 and 193 of the Constitution of Kenya 2010 and Section 22(2) of the Elections Act to vie for the position of governor and deputy governor of Meru County in the forthcoming election of 9th August 2022. Those are not my words, end of quote. The court is also not able to hold that the determination by the two-judge bench in Nairobi High Court petition number 7 of 2018 operates res judicata to bar the petition herein. Indeed, the decision of the court left the matter of nullification of the petitioner's degree in accordance with the law. The court will therefore reserve the right of the petitioner to proceed with the hearing of the petition, while allowing the IEBC to deal in the exercise of its constitutional mandate with the process of nomination for candidates set for the 9th August 2022 elections. Therefore, at paragraph 23, the preliminary objection succeeds to the extent only that the issues of resolution of disputes of nominations rest with the IEBC. The notice of motion dated 31st of May 2022 will be struck out, as it seeks to bar the exercise of the constitutional mandate of the IEBC dealing with nominations dispute. Paragraph 24, I have set the conclusions there, which is that the court therefore accepts that the interpretative jurisdiction of the court under Article 165 of 258 would exist to allow the court to deal with the question whether a particular candidate qualified under the Constitution, under the Elections Act, to vie for a particular position in the election. And the court also considers that there is an aspect of that determination that is covered by the law of the process of nominations. The provisions of the Constitution and Elections Act, respectively, under 884(e) and Section 74 placed the jurisdiction to deal with the disputes around nominations with the IEBC. And the court, on the principle of constitutional avoidance and the rule in the case of Speaker of the National Assembly versus Karume, 1992 EKR, defers to the IEBC to deal with the nominations process and any dispute arising therefrom. On hearing the petition, under its interpretative jurisdiction, the court may make declarations of ineligibility sought in prayer A of the petition, and with such determination the court might make any consequential orders, including invalidating the nomination if it shall have already have been made of the third respondent to vie for the position of governor of Meru County. An election petition also upon the elections, if the third respondent were a successful candidate, may also achieve the same result. The cost involved would be small to pay against the enforcement of the third respondent's political rights under Article 38 of the Bill of Rights of the Constitution. The court is mindful that the process of nomination... Court, you have dealt with that? The court is mindful that the nominations process has been initiated and the nomination day within the meaning of the Elections Act has been set by gazettement in the official Kenya Gazette. The respondents have also made corresponding arrangements with no doubt time and resource investment. Without expressing a verdict on the merits of the petition, the court finds that greater harm and hardship will be occasioned by the stay of the nominations exercise in respect of the third respondent in particular, or all the candidates if that were to be the order of the court. At paragraph 28, therefore, the petition would not be rendered nugatory as the petitioner has other avenues of challenging the eligibility of the third respondent as candidate for the position of governor. So we make the conclusion that we let the nomination process proceed and the petitioner may pursue other available avenues for redress before or after elections by election petitions. Therefore, the specific orders of the court will be accordingly, for the reasons set out above, the court will let the IEBC conduct the nominations in accordance with its mandate under Article 88(4)(e) of the Constitution and Section 74 of the Elections Act. If the petitioner is still aggrieved by the decision of the IEBC, he may set the petition down for hearing, and the court, upon hearing the petition, may cancel the nomination before the election day on the 9th of August if it determines that the third respondent is not qualified to vie for the position of governor. Or by petition after the elections, the election court may declare the third respondent, if he be the successful candidate, that he was not validly elected. Therefore, at paragraph 31, consequently, the court will direct that the preliminary objection is successful to the extent that the disputes, such as part of which is before the court, relating to nomination of candidates, is a preserve of the IEBC under Article 884(e) of the Constitution. At paragraph 32, the notice of motion dated 31st May is struck out. However, the petition shall continue on a date to be fixed in consultation with the parties after the respondents file their replying affidavits or other response to the petition within 7 days from today, and the petition shall therefore be mentioned for directions as to hearing on the 9th of June 2022. Costs will be in the course of the petition, and that is the order of the court dated today, the 3rd of June 2022. Thank you very much. I'll give you copies of this one shortly. You can deal with the next one. Number 5, it's Dixon Mwenda Gevenji and IEBC. Yes. And for
here for the petition alongside my colleagues, Mr. Mutuma.
Yes.
And Mr. Mutego.
Mr. Maranya for petitioner, with Mr. Mutuma and Mr. Mutegi. And Mr. Mungera is for the 1 and 2 in this one also?
Yes, my lord.
1 and 2. And for the respondents, there was Mr. Munene?
My lord, yes. Present with Mr. Ngentu.
Mr. Munene with Mr. Ngentu
Yes. For the 3 and 4.
for 3 and 4.
My lord, perhaps I can go on record that I somehow managed to attend, even though I have not been very useful to the court.
Better late than never. Did you say that
I mentioned you.
Yes,
you did?
I mentioned you. Maybe you can
Let me confirm that I have that. The Bible says everybody will be paid equally, right? So this is Mr. Mugambi with Dr. Ndiokolu. Okay, there you are. The record will show. Then for this one, there is no appearance for the 1 and 2 IPs. That's still the position. Okay, again in this, the decision is in typed format. I'll give you copies of this. So I'll read for the sake of the stakeholders who are before the court the determination, so that you see where we have come from. Similarly, Article 884E of the Constitution grants IEBC jurisdiction to deal with disputes relating to nominations. The procedure for which is set out in Section 74 of the Elections Act. The issue of nomination and clearance of the 3rd and 4th respondents to vie as candidates for the positions, respectively, of Governor and Deputy Governor of Meru County raises a nomination issue within the meaning. You bear with me, this one was done with quite a rush, so there are typos to be done. Within the meaning of the Elections Act, Section 2, by its prayers seeking conservatory orders to restrain the 1st and 2nd respondents from, and I quote, accepting clearance document, processing nomination certificate, and or clearing 3 and 4 respondents hearing to contest for the position of Governor and Deputy Governor of Meru County until the petition is heard and determined. The notice of motion in this matter dated 31st of May 2022 clearly seeks to interfere with the mandate of the IEBC from conducting the nominations, at least with respect to the 2 respondents. It is a matter that the court does not take lightly and will do so only in clear best of cases of breach or threatened breach of the Constitution. Being a nomination dispute to the extent of the question whether the respondents possess valid degree certificates, the court shall defer to the IEBC for determination and resolution of any disputes that may arise upon the determination in accordance with the Article 884E of the Constitution and Section 74 of the Constitution. And the case of Godfrey Mwaki Kemadhi there and 2 others versus Jubilee Alliance cited by the objector is cited. On the issue of the application for conservatory orders, the court notes that in addition, the merits of the application, the existence of letters, phone calls, information on the one hand, and written confirmation from the Kenya National Qualification Authority and Commission for University of Education, on the other hand, giving different positions as to the qualification of 3rd and 4th respondents, does not help the court at this stage of interlocutory conservatory order to make a determination. While the primary burden of proof in the petition lies with the petitioner, and while the burden is the burden as to the possession of qualification may shift from the respondent upon the petitioner producing evidence to a prima facie case. The court does not find that such a prima facie case as will justify shifting the burden of proof of the respondent has been demonstrated. The court has been urged by the petitioner to rely on his private investigations into the matter of the third and fourth respondents' qualifications, and the court does not find that such evidence, not coming from statutory investigative agencies, is cogent sufficiently to support a prima facie case. Evidence of telephone conversations with various universities allegedly by the petitioner, even less so. The test for standard of proof in civil cases is described in the House of Lords decision in R&H minus 1995, that the more serious the allegation, the more cogent the evidence necessary to persuade the court to find a fact more likely than not, and therefore proved on the standard of balance of probability. The court must return a finding, in this case, that the petitioner applicant has not demonstrated on a balance of probability, a prima facie case capable of supporting the grant of conservatory orders, as prayed in the motion. Moreover, it is the court's view that the petition is not rendered nugatory by the refusal to grant the conservatory order. The petitioner may be heard on dispute by IEBC and thereafter by this court if the third and fourth respondents are cleared, and subsequently by petition as held in petition number 6. The petition, when heard by this court or by the three-judge bench, if the application from Mr. Mungera for referral to the Honorable Chief Justice is allowed, may make declarations as appropriate in the matter after hearing the dispute on its merits. Further, the petitioner may pursue the election petition as earlier indicated. By this order, the court shall enforce the political rights of the third and fourth respondent under Article 38 of the Constitution to nomination and election, while at the same time preserving the right of the voter petitioner to challenge the nominations or election in accordance with the Constitution and the Elections Act. Therefore, the specific orders of the court are that the court makes an order allowing the preliminary objection to the extent that the IEBC shall deal at the first instance with the nomination dispute that may arise following the nomination exercise to be held on the 4th of June with respect to the third and fourth respondents. For hearing of the main petition on the challenge of the qualification, the court shall give directions on the matter on the 9th of June. The application for conservatory order prayed by the notice of motion dated 3/1/05 is consequently declined. The cost of the application and the preliminary objection shall be cost in the course and will abide the hearing and determination of the petition. That is the order of the court dated today, the 3rd of June, 2022. Thank you. You bear with the court for this one here, for the typos to be done. There is nothing further. I wish you well. Have a good evening.